Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reisch. Thanks for watching. If you haven't done so already, please hit that subscribe button and always hit that little bell in the corner so that you receive notifications of when we go live or put up new content. First on the docket, lawyers cannot counsel someone on how to commit a crime and to get away with it. Let's talk about a very good example, all right? A licensed Nashville attorney has been suspended for 4 years. That means he's not going to be practicing law. And at the end of that 4-year period, assuming he can show that he is a changed man and is in good standing, he still has to take the bar exam to become a lawyer again. So this whole story starts out by an attorney by the name of Winston Bradshaw Sitton, and he's an attorney in Nashville, Tennessee. He was giving advice over Facebook, which is not a good place to give legal advice, even if you know the person or not. Not a good thing to do over the internet. And as you may note here on Crime Talk, we've never said this is how you commit a crime. We often say how people get convicted of a crime, but we're not counseling anybody on how to beat a crime. So this attorney back in 2017 responded to a Facebook friend who described a very tumultuous relationship and breakup with her father's child, and inquired about the legality of carrying a gun in her car. Well, as the story goes on, attorney Sitton apparently wrote that if a woman wanted to kill her ex-boyfriend, she should, quote, lure him into her home and claim he broke in with the intent to do harm and she feared for her life. Now, these are all facts that came out at the Tennessee Supreme Court hearing. Well, Sitton's, whose Facebook page described himself as a lawyer, also emphasized in the comment that this advice was given, quote, as a lawyer, end quote, and that if she was to remotely be serious, she should delete this thread because it could possibly be used as proof of premeditation against her at trial. So, he specifically said, if you want to kill him, then lure him into the house and claim he broke in with the intent to do you bodily harm and that you feared for her life. Even with the new stand your ground law, the Castle Doctrine is a far safer basis for use of deadly force. The woman responded, I wish he would try, to which Sitton advised her to keep mum about this. Clearly, Mr. Sitton must have realized that he may have crossed the line. The Tennessee Supreme Court did, obviously indicating that he is no longer a lawyer, at least for the next 4 years. Now, how did Mr. Sitton get in trouble for this? Although the woman later deleted the Facebook post, her ex-boyfriend became aware of the exchange and brought screenshots to the Shelby County District Attorney General, Amy Weinrich, who then passed the screenshots to the Tennessee Board of Professional Responsibility. The 4-year suspension is actually a 1 year in which an active suspension and the rest is on probation. This case is a cautionary tale, obviously about the ethical problems that we can befall lawyers giving legal advice on social media. Yes, there is no formation of an attorney-client relationship necessarily, but if the individual on the other end believes that they are engaging in an attorney-client relationship, then the attorney has a problem. In this particular case, he stated this is giving advice as a lawyer. You can't do that. And guess what? When you give your advice to the general world like that, there's no attorney-client privilege whatsoever. Maybe he had taken a few adult beverages when he was giving the advice out, but needless to say, it didn't work out well for him. Now, Mr. Sitton wrote in the proceedings that he absolutely contests the findings that my gratuitous commentary offered to a battered woman who was being threatened and abused and harassed by her son's father was legal advice how to commit a crime or in any way violate his legal duties as either a citizen or as a lawyer. Well, the court stated, we agree with Mr. Sitton that it is hard to conceive of any reason why a lawyer, any lawyer, would offer instructions on how to commit murder and stage a concocted defense. So there you have it, ladies and gentlemen. I assure you, people should be very cautious when giving advice over the internet. Certainly, you have to be careful indeed. Let me know whether you believe Mr. Sitton got what he deserved from the Tennessee bar, or do you think that they blew it out of proportion? Mark Means, Lori Vallow's attorney, is at it again. Mark Means has never tried a felony criminal case to trial. Mr. Means has filed motions wanting a bond reduction because he thought that a phone call was recorded. The remedy for that is that the call could not be used. That would be it if it was ever admitted in court, because it would be attorney-client privilege. Nowhere have I ever seen that would warrant a bond reduction. And guess what? The court found that was not the applicable remedy, and the bond reduction was denied. Then Mr. Means tried to disqualify Mr. Wood, the prosecutor, for a conversation pre-interview with a witness explaining what generally was going on. Mr. Means made allegations over the top that this was witness intimidation. This was witness tampering. It was nonsense. I said it was nonsense. The court held a hearing on it because it had such serious ramifications regarding literally someone's ability and license to practice law. The court found Mark Means' allegations were nonsense. Now guess what? Mark Means has now filed a supplement to his motion to compel. We talked about the motion to compel last week, basically saying, I'm asking that everything be turned over. Well, now Mr. Means has supplemented his declaration, so to speak, as it relates to that motion to compel, and saying, on January 19th, a hard drive with additional discovery, records, documents, recordings, statements, phone calls was mailed to defense counsel John Pryor. But to date, no additional hard drive has been provided to my office. And then Mr. Means goes on and makes a further allegation. This is another incident and action of the state to wrongfully withhold relevant and discoverable evidence in this matter, with further obvious obstruction of the defense and the defendant. Mr. Means needs to stop being so over the top. Okay? Now, this is the kind of situation where we know that Mark Pryor and Mr. Means are in an office sharing situation. That's very common in professional situations where somebody rents a space, they rent offices, and they share the common expenses with all the parties. It reduces the cost of overhead. So it would seem to be, if Mr. Means didn't receive discovery, that he could pick up the phone or maybe shoot an email to the prosecutor saying, hey, I haven't received this information yet, this new discovery, this hard drive. What's the status on that? You know, that's the kind of thing that's resolved by the, professionalism in the community of attorneys to get things done. Oh, that's right. Yeah. But when you call people liars and unethical and accuse them of criminal conduct, maybe you're a little gun shy to pick up the phone and actually ask them something. Maybe they won't take your call unless there's a third-party witness around. Or maybe they say, we'll talk to you in court. I've had those types of circumstances with some prosecutors over the years. We're like, you know what? I can't talk with you. I've got trust issues with you. Just talk to me in court on the record. So there's no way about anything about this. But in this particular situation, Mr. Means is the one I think that is being a little over the top. Now, where does it go even more over the top? Is that Mr. Means has filed a motion saying that he cannot meet face-to-face with his client, Lori Vallow, and the attorney-client room basically is small, inadequate, and they have this, what do they call it? Oh, that's right, windows between the defendant and the attorney. Now, we all know this is the first time Mr. Means has done a criminal case. Perhaps this is the first time that he's been to the jail on a case. We must assume so. Well, Mr. Means has attached to his motions various photographs of the circumstances in which he has to work with. Oh my God, let's take a look at this. A glass window between you and the defendant, a telephone that only connects to the phone on the other side, so it can't be listened to, and a small, uncomfortable stool to sit on. And he shows, the working conditions, how terrible this is. Mr. Means, I'm not sure what you were expecting. Yes, and even being able to have to hold up documents. Actually, this looks like a very large meeting area. Now, Mr. Means complains that this is because of the COVID-19, and therefore he wants his client to have a cell phone so that Lori Vallow and Mr. Means can speak with each other basically anytime they want about the case. Now, let me tell you this. The court, although the court has great powers, the court has no authority whatsoever to tell the jail how to run their jail. I'm telling you, this room, this situation is not anything unusual. In fact, this is actually pretty large an area to lay out. I have gone to some meetings with clients where we maybe got a little corner in the cafeteria if it was at a prison. If it's at a detention center, literally it's the size of maybe, on my side, 3 by 3, just enough room, and you have to turn carefully to sit down and close the door. So I'm not sure what Mr. Means is upset about. This is normal conditions. Get used to it. It's part of the harassment package, Mr. Means. It is what it is. But you don't let it get you down. You simply deal with it and don't let them interfere with your preparation for trial. Now, I'm sure Mr. Means has asked the jail if he could have a cell phone for his client. And I assure you, I'm going to go on a limb here, but that jail said no. And if he hasn't, he's going to look like a fool when he goes in there and says, Judge, I want my client to have a cell phone. Cell phones are not permitted in custody for obvious reasons. You can't have people on the outside. They're in custody. Everything is recorded. It's called good order and discipline. So once again, Mr. Means is out spending time, energy, and resources, and I'm talking about dollars, chasing issues that are of no relevance. Maybe he'll get some play. I don't think he's going to. These conditions are what you have to deal with when your client is in custody. It is inconvenient, but you can communicate via the phone, usually during a call on an attorney line that's not monitored. And even if it was monitored, they couldn't use that at trial against you in any way, and they shouldn't record it. If they find out they did record it, they should be deleted. But bottom line is, Mr. Means, if you have something of great significance and importance to talk to with your client, you go to the jail so no one's listening. Mr. Means wants the video camera in the attorney-client room also turned off. Even though there's no recording, he wants that turned off. Don't think that's going to happen. The court is not going to tell the jail how to run their jail so that this one inmate, this one defendant can communicate with her attorney, when apparently all the other inmates and all the other attorneys have been able to do it just fine. Mr. Means, I think you are so wrong in this particular case. You're wasting your client's money and you're wasting your time when you should probably be focusing on coming up with a defense for your client. This is all red herring type of stuff. And I hate to say it, this is one of the reasons why I really do not like civil work, because this is the kind of nitpicky BS that civil attorneys come up with. They always want to play some sort of game of gotcha. Criminal stuff is like, here's the evidence, maybe have a motions hearing, well, let's go to trial. This is nonsense. You're not going to wear down the government playing these little games. All this is doing is spending your client's money, wasting your time when you should be preparing for a trial. Now, let's get straight to the docket. Ghislaine Maxwell, she is asking the judge to dismiss her case. Why, you may say? Is it because she's innocent? Is it because she just doesn't deserve to be in prison because she is special? No, it's because she's saying that when that guy named Jeff pled guilty back in Florida years ago, that no one else was going to be charged, that agreement covered Ghislaine Maxwell. Now, the U.S. Attorney's Office says we weren't bound by that agreement with that guy named Jeff when it lodged sex trafficking charges against him back in July of 2019, saying the agreement covered only Southern Florida and didn't cover that guy named Jeff's accomplices. Now, that guy named Jeff, his attorney, was going to invoke that agreement as his defense, but unfortunately, he had that little mishap in that jail cell in Manhattan, and the case is now dismissed. Now, a lot of people think that agreement must be valid because they're asking the court to invalidate it so that other people associated with that guy named Jeff can in fact be prosecuted. The other reason why Ghislaine Maxwell is asking that her case be dismissed is that the grand jury did not have enough Black or Hispanic grand juror members on it, and therefore she is raising the claim that there was not a fair cross-section of her community in the grand jury that obviously issued the indictment against her. Now, Ghislaine Maxwell is neither Black nor Hispanic, but she's simply raising the issue to preserve it for appellate purposes. Don't think that one's going to get a whole lot of play at all. They're probably going to have a hearing as it relates to breadth of the agreement with that guy named Jeff and whether all United States attorneys' offices are bound by that or whether it was only the Southern District in Florida. That one may actually get rather interesting. It's the 1-year anniversary when Ghislaine Stauch went missing. That's right, January 27th, yesterday, Leticia Stauch reports Ghislaine Stauch missing to the El Paso County Sheriff's Office. Needless to say, that has set forth a lot of events. We also know that Leticia Stauch was arrested on March 2nd in South Carolina. That included the charges of first-degree murder. A lot of us should also know that there have been 2 competency evaluations as regards to Leticia Stauch's mental health issues. And as many of you know, Leticia Stauch has had 2 competency evaluations, and both doctors have come back and said that Leticia Stauch is competent to proceed to trial. We have a preliminary hearing set next month. Now, also, March 2020, Gannon's remains are found off a roadway in Florida. Ultimately, those are identified to be the remains of Gannon through dental records. And who can forget, new charges are filed against Leticia Stauch as another inmate tells the deputies that Leticia Stauch is trying to escape from jail. Needless to say, this is a tragic story. Anytime a child has their life ended at such a young age, it is a tragedy not only for the family, the victim, but a community. So we'll continue to follow this case. It is obviously going to be an interesting one, and who knows what Leticia Stauch is going to do at any time. Ghislaine Maxwell, we all know who she is. Well, she better hope that she is covered by the non-prosecution agreement that her boss signed, because otherwise she's in big trouble. Now, a lot of documents have been coming out of a civil case that was settled back in 2017, and people are trying to get those documents released, and the judge keeps releasing them. Well, if the statements in that civil case obviously led to a settlement of some kind, we don't know exactly what, but needless to say, those same victims from the civil case are the victims in the criminal case. And guess what? It means those statements, those victims are locked into their statements. They can't now change them. They can't say, oh, I don't want to play along in the criminal case anymore. And it's not good for Miss Maxwell for sure. It's basically, she was, as alleged, and we'll give her the presumption of innocence, but it looks like, allegedly, she was basically pimping young children for that guy named Jeff. She would recruit kids from high schools. She would basically encourage them to perform sexual acts, obviously with that guy named Jeff, along with a list of other people. Now, obviously, the list that we would like to see are the list of people that went and engaged in criminal conduct with these young girls at the residence down in Florida or down in the Bahamas or in New Mexico. That's the list that people should be really interested in. And like I said in the past, it's interesting that so few of those names have ever come out. That is the one card that Ghislaine Maxwell has to play. And if she is going to do it, I would think she would do it either A, now, or B, right after her motions hearing, because I don't think there's actually going to be a trial in this particular case. But we'll see if Miss Maxwell wants to air all the dirty laundry. She is basically looking at a life sentence if convicted. So what does she really have to lose? We'll see you next week on Crime Talk. Have a great weekend.